Duly noted.
I'm not going to make any comments about who I blame for Odyssey, but it's not Caldwell County why yours Odyssey is down. I can tell you that.
Yeah, we could talk about why Odyssey goes down for the rest of the day.
Yeah.
Oh no, it's making me go through Gmail. Um, let's see. Don't see Steve yet, so he's still got a little time to wait for him.
Okay. All right, we'll take a couple minutes.
Okay. Uh, let me just call. Oh, I'm streaming. Okay. Oh, I see. Okay, good. Maybe one more minute. Damon
Okay.
says that it's working, so.
Okay. Yeah, I'm sure there's a lot of information and a lot we'll probably try to cover today, so we'll probably need to get started pretty soon.
Yeah, yeah. Why don't we go ahead? I think he should be able to join whenever. He said that he RSVP'd yes, but he can just hop in whenever he's ready.
Okay.
Yeah.
All right. So everybody, we will go ahead and get started. I am Takia Lewis Blaylock, and I am the chair of this subcommittee. And I'll go ahead and I'll read the ethics statement. Members of the committee are hereby advised of their duty under the State Government Ethics Acts to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest. Does anyone have any conflicts that they're aware of? Okay. All right. Well, seeing none, we can go ahead and get started.
Sorry, I don't think these are actual conflicts, but I thought I'd mention a couple of things.
Okay.
Oh, okay.
And part of the reason I was invited to join this committee, I think, was because I'd spoken up because I have two special needs kids who we dealt with IDEA in these hearings. And fortunately, I'm a lawyer and my wife's educated, so they went fairly well for us. And one of my law partners is the attorney for our local school board. I don't think those are actual conflicts, but to the extent they might be an issue, I thought I would raise them now.
Okay. Yeah, I appreciate it. I don't think that would be any kind of conflict. Tessa, do you see any issue with that? Okay. All right. So we are here to meet as a subcommittee to address the proposed advisory opinion on the role of lay advocates in special education proceedings before the Office of Administrative Hearings. And I have never done any work in that area, so I have zero input on it. But before we dive deep, I know we have some guests. So let's introduce ourselves, the members of the subcommittee, and then we can have our guests introduce themselves, and then we can go ahead and jump in and get started. As I said, I'm Takia Lewis Blaylock, so I'll just go ahead and throw it to the next person.
Okay. I'm TJ Rohr. I practice in Caldwell County and I have two special needs kids. I guess we've all heard that. I have done some OAH stuff, but not in the area of IDEA stuff. Again, I have some personal experience, not at the OAH level with IDEA. We always got it resolved at the school level, not even having to go to the school board. But um, that's kind of my background.
Okay. All right, who is
I'll
next
go.
on the list? Okay.
Sure. I'm Tessa Hale. I work at the State Bar. I'm counsel for the Authorized Practice Committee and also do a little bit of attorney discipline. I actually do have some experience with special education law. Just before I started at the State Bar, I was an education lawyer at Legal Aid, but did not practice before the OAH.
I don't think I have it set up. It's weird. I can't see everybody who is here. Are there any more subcommittee members?
So
Okay.
Jane, yeah, Jane.
Good morning. I'm Jane Gilchrist. I've recently retired from state government. When I did work for the Attorney General's office, I appeared for years in front of the Office of Administrative Hearings for the Criminal Justice Commission on issues of law enforcement licensure. And that's why I'm here, I guess.
Okay. All right. Anyone else on the subcommittee? I don't want to jump. Okay. All right. And so we can move on to our special guests. Tessa, can you let us know who we have on and then we can have them introduce themselves?
Sure, I'll let them introduce themselves. You guys know best what you do, and we're really excited to hear from you. So we'll see what you have to say.
I don't mind going first unless you want to go, Tammy. I'm Stacy Gahagan. I am one of the founding partners of Gahagan Parity. We are, I think, the largest law firm in North Carolina that represents children with disabilities, and we practice statewide. I opened my original firm in 2014, and Tammy and I worked together there before she opened her nonprofit and merged with Ann Parody, who also practiced in special education law in 2019 to form our firm. And we practice regularly. I head up the litigation department in our firm, and we practice all the time. I mean, we probably file, I don't know, maybe 100 petitions a year. Like, I know, maybe that's too much. Maybe 50, somewhere between 50 and 100 a year in the Office of Administrative Hearings.
Okay, and I'll go next. I'm Tammy Com, and as Stacy said, I'm an attorney also practicing in the area of IDEA litigation in front of the Office of Administrative Hearings. And I founded Legal Services for Children of North Carolina about a decade ago, approximately, and solely represent low-income families in these disputes and file regularly. And essentially, what Stacy said, I started out with her and continued on to fulfill the mission of serving low-income families. And I'll turn it over to Steve Rawson.
Good morning, everybody. Steve Rawson here. I am with the law firm of Tharrington Smith and practice exclusively in the area of representing boards of education around the state. One of the areas that I spend a fair amount of time on is in special education litigation specifically. And so I'm obviously very familiar with Stacy and Tammy and always appreciate their input on these cases. This is a large portion of my practice. I spend a lot of time in OAH, just finished a hearing on Monday in one of these cases. So yeah, with the subcommittee's permission, I'm going to keep my camera off. You'll see I'm in a hotel lobby here for the School Boards Association Fall Law Conference that I'll be presenting at in a little bit. So I will leave you off, but I will be here and fully participating for the next hour and a half.
And I'll mention here that Keith, well, thank you all first. I'll mention here that Keith said that he might come. He's in mediation now, but we'll see about that. If he jumps in, we'll just let him introduce himself whenever he comes. You're muted, Takia. Judge Lewis Blaylock.
I didn't mute myself, but I did earlier. Yes, I did. Sorry, yeah. All right, so I'm gonna, kind of try to get the discussion going, and I hope that you all will jump in and answer the questions or facilitate the answers to the questions as much as possible. But I want to know about, you've told us a little bit about what you practiced and um, I know that some of you work with low income clients. So what would be the demographics mostly of your clients, the basics of your practice, anything else that you might want to share to give us more background than what you may have given us in your introduction.
I mean, I can start with that. I know Tammy's practice is specific, like for students that are at a certain income level. Our firm represents families at all income levels. We do contingency cases that we accept referrals from legal aid and from disability rights, and then just families that find us, that need contingency work. And then we also have families that pay initial retainers and then kind of on a partial contingency basis. These hearings, I think one thing just to say from the very beginning, and I don't think Steve or Tammy would disagree with me, like are very long. I like to say that the longest special ed hearing I ever had was 29 days. Definitely an outlier. Tammy and I did one that was 21. Now they tend to be like 1 to 2 weeks. And so they are long cases with experts and things like that. And so really kind of the reality is that even parents that can afford initially to pursue litigation, it's really not something that is sustainable, like of being able to, if you can imagine like what those fees are like for the school district and for the parents. So we have I don't know if there's much more to say about that, but just for you to have some perspective of how long that the hearings are. And they're also now starting to bifurcate hearings and to deal with like if there's a statute of limitations issue or if there's an immediate stay put issue, like there are some things that are being bifurcated into 2 separate hearings. But they all require expert witnesses from the parents. And so that is kind of the additional costs for the families. And I know the school districts will often also contract with experts.
Thanks.
And I'll also add that I mean everything that Stacy said is true. If a case gets to hearing, that is really what you're looking at. But there's also so many of the cases that do settle, and it's the goal of OAH to encourage settlement. And there's a built-in resolution process that encourages settlement. But even during the settlement process, and it's so critical to try to settle if it's a settlable case. But the expertise that needs to be brought to bear during the settlement conference is key in being able to get to that spot so that you don't end up in a hearing unnecessarily. So, the attorneys, even if you're not going before, getting to the stage of hearing as much as others, you're still, sort of participating in that settlement process regularly. And it's key to being able to resolve.
Yeah, I would just add to that that it's nice when you have attorneys that are on the other side that also practice special education law because you are able to resolve cases. You're very quickly able to figure out which cases that you can find common ground on for settlement and then identify the rare case that you can't and that you have to go to a hearing on. And so we really appreciate when it becomes difficult is when you have people that don't really understand exactly kind of what the law is and what the rights are, and that can really impede settlement, drive up attorneys' fees unnecessarily, and delay children from being able to get the services that the parents are looking for, and that the school district often is willing to compromise and to find some compromise to be able to provide.
Okay, great. I had no idea that those hearings lasted longer than some murder trials. That's very, I don't want to say crazy, but crazy. So I would assume that you've all had some type of contact with lay advocates. What has been your experience with that? Like, has it been a good experience, bad experience? Like, is it in more cases than not? How does that work?
So I may be able to speak to that from the school system's perspective because it's more likely that we would be across the table from an advocate in these situations than Stacey or Tammy would. They often are picking up cases after there's been an advocate involved, which has its own complications for them, obviously, as they've shared. I would say that one, we value the role of lay advocates early in the process, and the IDEA does provide for the involvement of people with specialized knowledge to assist the parent who may not be lawyers. And so there is a niche, and I don't mean this in a derogatory way, a niche business, if you will, of lay advocates who advertise themselves to parents with children with special needs, saying, "Hey, I was a special education teacher, or I am a parent who is now, my child is older, but I, went through this whole process for years, and I can help provide some guidance on that." And that role can be important in helping parents who, because the IDEA is a complicated statute, um, and the system is fairly opaque. And so the opportunity for us as a school system to have productive conversations in IEP meetings at the school level can certainly be helped when there is a lay advocate who does have some of that vocabulary, does have some experience with that process, and can say, this is how an IEP meeting works, and these are some of the questions we should be asking, and this is some of the information that you should try to review beforehand. Here are some of the menu of services your child may be able to receive. That can be helpful. I will say on the flip side of that, it can be very unhelpful from the school's perspective sometimes when a particular advocate comes in and starts lecturing the team and starts lecturing me as the lawyer, telling me I don't know what the law is, which is always a delightful experience. But that tends to be rare at that level, right? That we do have folks who are providing support for parents who may not be able to afford attorney, or may not know yet that they need or want an attorney kind of at that level of intensity, but are just looking for some help. And so that's a great space for that. I think that's very different when you get to litigation. As Stacy and Tammy said, these hearings are complex. The law is complex even for us as people who've been practicing this for more than a decade. It is there are very gray areas, and both the procedures and the substance can get very complicated. And I have found that when lay advocates get too far into that process, it can be very difficult to settle a case, which is what we're looking to do, right? These cases are supposed to be resolved early, so we don't have 29-day hearings. That still makes me shudder every time I hear Stacy say that. I think my record is 14 or 15, so but usually 3 or 4 or 5. And we want to resolve these cases. And so I've had cases where the parent advocate has convinced the parent that they're entitled to millions of dollars of monetary damages. Well, the IDEA does not provide for monetary damages, period. Like there's no scenario where you can get monetary damages under the IDEA. You can get reimbursement for expenses in certain cases, but not monetary damages. And so once the parent has that idea in their head, settlement is incredibly difficult. And we end up going toward hearing and putting a ton of resources into the litigation process that would better have been put into educating the child in the first place. So I think there's a point at which, and it frankly falls pretty closely aligned with where the line between unauthorized practice of law is, where it becomes a barrier to success in these cases.
And I'll just add, if that's okay. I mean, Steve is exactly right. I think, we completely agree with what Steve's saying. And I think there is, potentially a role for, persons with specialized knowledge of the student to come in and kind of, hold hands with the parent and help them, maybe understand the evaluations and understand kind of the process as you go through. But where it becomes a problem is when they start to cross over in that line in saying your rights have been violated. And exactly as Steve said, on kind of our side of the aisle, we might have people that come to us who have been previously engaged with an advocate, and they're saying, okay, now you need to go to a lawyer, and they've been told sort of, just things that are incorrect about the law, or things that they're entitled to that are incorrect, or that you can't prove and that you're not going to get. And so, from a legal standpoint, we're like, well, this may have happened, but from a legal standpoint, that's not how the law works, or you're not going to get this in this circuit, or, and so on and so forth. So it does become a place where people are misinformed and what ends up happening is that the student is the one who ends up suffering because they're not being told, accurate legal information because the person's not a lawyer. They're either not settling or they're going to hearings and losing, creating law that's bad law that further hurts students. And so we found that it's quite problematic on our end as well.
Can I just chime in here? I'm wondering if you all could, Steve, you mentioned just the complexity of these cases, just procedurally and substantively. What contributes to that? What rules apply to these proceedings? What is it like to practice before the OAH? What rules do you have? Why is it so hard?
So I'll start there, and I know Stacy and Tammy will have more to add. But in brief, it's because it's the intersection of so many different areas of law. So you have obviously the IDEA itself, the central federal law. There is state law implementing the federal law. You also have the overlay of disability-related law, the Americans with Disabilities Act, Section 504 of the 1973 Rehabilitation Act. And then you've got the administrative process. And here in North Carolina, school board issues, local government issues like that are not usually before the Office of Administrative Hearings, but in the very narrow context of special education, they are. And so now you have an interaction with OAH that is not common in the school environment as well. And so when you're juggling four different sources of law and procedure, but two, the different paths that this can go, because once a petition is filed, and it needs to be filed with the Office of Administrative Hearings, and if we go through a hearing, that hearing can then be taken either to state court or federal court, depending on the petitioner's desire. And they usually end up in federal court, but that federal court is handling it, the district court is handling it as an administrative appeal on the record generally, although it has the authority to take additional evidence and consider that if there is appropriate additional evidence that has become available since the institution of the petition. You also have significant statutes of limitations issues that are quite vexing. I know for both Stacy and Tammy and for our side that the IDEA leaves the statute of limitations to the states. It has a default 2-year, but the states can set it. North Carolina uses a 1-year statute of limitations for special education claims, but there are exceptions to that that can be invoked, and whether those exceptions apply and how far back they can go are very complicated issues. That goes back to what Stacy was saying about bifurcated hearings. We often have to have a hearing before the hearing to decide what the hearing's about in terms of the timeline. And so many of these cases, right? A child is in the public school system for 13 years at minimum, and under the IDEA can actually stay through age 22 if they're unable to earn a diploma as a result of their disability. And so you have kids who may be, and then there's pre-K services and things. So you can have a kid from age 3 to 22, and a lot can happen in 19 years. And you can have a dispute when they're 6, and you can resolve it amicably and move on. And then you can have a dispute when they're 8, and it goes all the way through a hearing, and someone wins and someone loses. And then you have another dispute when they're 12, and it goes on and on and on. And sometimes parents don't bring the claims when the kid is 6 or 8 or 10, and now they're 12, but they're 3 or 4 years behind because of various, either because of the child's condition and their needs, or because something the school system didn't do. And it's usually a combination of all of these things. And now the parent's trying to make 4 and 5 years worth of claims, and we're saying no, it's a 1-year statute of limitations. So that's just I don't know. I've strayed from the question, but I think it gives you a sense of why these cases are so complicated.
Yeah, and I agree with everything that Steve said, and I'll just chime in that the other part that makes it complicated is that you have, because it's a federal law, of course, you're getting decisions from all the circuits, and so they're really kind of a lot of times very discrete issues. So there may be an issue that the Fourth Circuit hasn't issued a decision on yet, so we don't actually have something that's binding for our circuit. So you're looking at all the other circuits, to for guidance and looking at the guidance that's issued from the federal government, with regard to, to how what the policy should be and how things should be implemented. But then a lot of times the decisions that come from other states are based on specific state regulations, right? So like in New York, you have to do an FBA. Like we don't have that same like regulation. We don't have that same law. We don't have regulations, but we don't have that same law like in North Carolina. And so you can look at the case and you're like, oh, this is a great case. This is really helpful. But in reality, it's based on something that is part of that state's law, and really understanding like how to drill down as to like what are cases that you can rely on, which ones are just inapposite, period. And that it's not an area of law to dabble in, I would say. And then the other part about the Office of Administrative Hearings is that at this point, I know that there are some proposed rules and we'll see what comes from those. But at this point, these cases have full discovery. So we have, where there are, in our experience, it's usually the school districts that are doing this, but taking depositions, but subpoenaing medical records, and so then you're having, protective orders that you're seeking to issue. There's a full motions practice. So in almost every case, there's motions to dismiss, motions for summary judgment, motions in limine, like all of these things that are happening, throughout. And so it's not something where it's just, that you only have to know kind of what the law is. You also have to be able to, to litigate it, as well. And so there's, I think those are kind of other parts that make it complicated. And so when you try to think about kind of what Steve was saying is that once it hits litigation, like it's game on, right? Like, it's a full, right? Like, almost from the very beginning. And so, and this, when a parent brings, parents have the right to bring a parent petition. Ideally under the IDEA, parents are supposed to be able to do this without an attorney and to do it independently. And there are some states that don't have full discovery. The decisions are made based on the educational record. The hearings last 6 hours. It's like different states have handled this differently, but that's not how it is, in North Carolina. And so you can see kind of how overwhelming for a lay advocate that would be, and then how quickly they would almost have to cross into unauthorized practice of law if they're actually going to try to, to help the parent.
So do you, any
Last
of
piece
you
I'll
all,
throw.
oh, I'm sorry. I was
No,
just
I was
gonna,
gonna say the last thing is the quick timeline, right? The IDEA has a 45-day timeline from the end of the resolution period to a decision needing to be issued by the ALJ. So it's not only complex, but it's really quick.
so do any of you practice in any other states outside of North Carolina?
So
I know
I
you
get
probably wouldn't, Steve, but
No,
I
I
do not.
get no. I think Keith, who is not able to join us, he also practices. I know in DC. I'm not sure about other states, but I often get brought in as like kind of pro hoc vici, like associated counsel, like for children in other states, especially on particular areas of law. But I have not been through a due process hearing in another state.
But I can add that I did attend law school in New York City, and I actually worked for an organization that's very similar to mine while I was in law school. And in New York, you can actually practice while you're in law school to a certain extent. There's certain things you can't do, like sign settlement agreements and so on. But I was actually able to litigate with supervision some of these cases in New York. And I know that the process is a lot more simplified there. And as Stacy was saying, hopefully these proposed rules that are, going through the process right now will help to simplify some of the, procedures and the process for parents. But it's not the case right now. But in New York, it is much more simplified. It's, this kind of very simple discovery where you're just sort of turning over the educational records. These hearings take place in front of an impartial hearing officer, not a judge, and usually can be over within a few hours, and you can kind of get a quick decision about, does your child in fact need some reading tutoring, or which is what a lot of these cases come down to. So they're very complicated even when the remedy is quite simple. The other thing is that here the burden of proof is on the parent. And that also makes it, just in terms of lay advocates, it's high stakes, and so that that makes it kind of an issue when the person's not really qualified. And in New York, it's the opposite. The burden of proof is on the school district to prove that they didn't provide an appropriate education, or that they did. So those are things that we'd love to see changed in our state, because we the school district holds all the records. The school district, they're very, powerful, and they have incredible attorneys like Mr. Rawson, and parents are, often kind of just on their lonesome trying to figure out what to do. But it's all the more reason why they should have qualified people, and not people who don't really aren't going to represent them well. So those are other reasons as to why it's, sort of more complicated here.
And the other thing I would just add to that, and Tessa I'm sure can echo what I'm saying, is that there are like legal aid and disability rights and the Duke Children's Law Clinic, like there are resources for families, like to be in addition to Tammy, to be able to get representation. But because of the complexity of these cases and of the hearing, that generally those cases are farmed out to private attorneys, and who only have the capacity to take so many, because they just don't, it's a lot, right? And so being able to commit that level of resources is really difficult. And so the families that they're supposed to be, you'd like to think, okay, well, we have these resources, for families, but if the process is so complex as it is, then those families can't really, it really becomes inaccessible from that standpoint as well.
And so, okay, so after these hopefully not 29-day long hearings, what happens if they get appealed? How does that work?
Yeah, so the other thing I would just add to that is at the end of the hearing, then each side drafts a proposed final decision, and those can be, over 100 pages, regularly, like in terms of, and then this for the ALJ to be able to look at and to pick and choose like what things they want to take from each side in their proposed decisions, and then to write their own. So that is a very time-consuming process, as well. And so after, kind of as Steve mentioned, we used to be a two-tier state. We're not a two-tier state anymore. So these decisions get appealed either to state or to federal court. In my experience, I've always been to federal court, but I don't know if Steve has had some that have also, been appealed to state court, but that option, is available. And so then you're in, especially if you're in federal court, then what happens, right? And as Steve mentioned, the federal court, like when the reviewing court especially in the Fourth Circuit, there's significant deference that's given to the decision of the administrative law judge. And so we've had a few decisions recently and so getting it right at the administrative hearing and really putting on kind of your best case at the administrative hearing is so important. And so that is another reason that it becomes it would be really difficult to take a case that like a lay advocate had done at an administrative level and try to be able to get anything at federal court, because as Steve mentioned, it's the district court judge can admit additional, you can request and you can have supplemental evidence added to the administrative record, but the standard is pretty much like it had to not be available, not that you just didn't use it and didn't know to put it on and those kind of things.
Yeah, and if I could add to that, one of the other things that I think the subcommittee is going to have to grapple with in this procedural context is that federal action is an independent civil action. So there's no direct appeal. You actually have to file a federal lawsuit challenging the administrative decision. And I haven't really thought about this that much, but if a lay advocate is allowed to take this through a hearing at OAH, I think the federal courts would shut them down if they tried to file an independent civil action, and that would be a legal practice issue from the federal court's perspective also. So I defer to the subcommittee on that. I have never looked at it in terms of how federal courts in North Carolina think about issues of unauthorized practice law and whether they just defer entirely to state law and its interpretation by the state bar. I don't know the answer to that, but it is certainly something to think about in terms of crossing fora. That it is you have to file a lawsuit in federal court to continue the process.
Now, have you all seen a lay advocate make it to the OAH process? And if so, does that happen a lot? Or is it, outliers?
I'm going to defer to Steve on that because he would have the best answer.
Um, I have had pro se cases go through OAH. And often I think in my experience, there's someone in the background when that's happening. Sometimes it's a lawyer, right? Sometimes there's a lawyer in the background, kind of, even if it's a friend who is advising the parent in some form or capacity, but not actually appearing or signing anything like that. I have not had a case where a lay advocate has actually taken a case to OAH. We've come close, but generally those we've either been able to resolve it, or when it came time for them to file something, they did end up deciding to go with an attorney at the last minute. And so I have not had to actually argue the question of whether the lay advocate is allowed to appear in OAH in these matters before an ALJ. But certainly I think it is more common that it is a pro se parent proceeding to hearing and that someone's in their ear in the background rather than somebody who's saying that they are representing the parent as a lay advocate at the OAH level.
That makes sense.
And I can just add to this that, there was a decision from the Supreme Court in 2006, the Arlington case, where the parents were trying to get reimbursement for their advocate, their educational consultant, like throughout the process, and, kind of tried to put it as expert fees, and it ended up with the decision, they said, no, that doesn't count as attorney's fees, which, could be, there is a fee shifting provision in the IDA, but that also what that has done is said you can't get reimbursed for, parents now can't get reimbursed for the expert fees that they incur, because the presumption under our law and under the case law for the federal courts is that the decisions of school boards are correct and that the deference is given, to the decisions of the IEP team. So parents have to have an expert. And so if you think about that's, at least $3,000, sometimes it's, can be a whole lot more than $3,000, but those are not reimbursable. And that all came from the case in 2006 from trying to get these fees for the educational consultant, that was guiding the parents through this process.
Can you explain the fee shifting provision, how that works, what that actually is?
Sure. So it's like with all civil rights kind of law that if the parents, I always say that the parents are entitled to a free, appropriate public education for their children, and if they have to pay an attorney to get it, then those fees are reimbursed if they win. And it's actually, and I won't say that they're 100% reimbursed. I mean, there's the next part where you have to go to federal court, to be able to seek reimbursement if the parties don't settle after there's a decision, even if the parents prevail and the school district decides not to appeal, then at that point, the parents still have to file in federal court an original civil action to seek recovery of attorney's fees. And there's a lot of case law about that. This is not supposed to be a whole second major litigation, but often they say that because often it is a second major litigation. And so that's, we just had a case that, we prevailed, we got reimbursement for the attorney's fees. But, when we first tried to settle the case, the fees were, I think, less than $4,000, right? And by the time we got finished, they were 250,000, right? So you just kind of, I mean, it's many years later, but like a lot of these cases settle, you know, maybe because you could have a debate about exactly what you need, but when you start thinking about kind of the costs to the school district, to the families, like it's just it makes a whole lot more sense to be able to resolve those cases. I mean, I've had cases where it took 7 years to be able to receive attorney's fees, and so again, kind of not the outlier, but usually it's like at least three if you have to go to court. So because there's all that same level of briefing and affidavits and and those kind of things. So I don't know if that's more information than you wanted, but it should give you an idea of it's a lot. And so if you think about kind of one of the things that someone told me a long time ago was that the further that you get in the process, the more that you understand the importance of the beginning of the process, and so, and I really think that that's true. And unfortunately, where I think we're seeing the lay advocates trying to cross over is into that beginning of the process when it's so important to, one, to get it right if you're bringing it, but two, to know what the claims are and when it's time to when it's time to settle or when it's time to try to resolve it at the IEP team.
And I'll also say that, in this field, the everybody has the same goal in mind. I mean, Steve has the same goal in mind as Stacy and I, which is serving the child. And these children are going to be in the school district, ostensibly through, high school. And so it's not the type of law where you are sort of like, okay, we were in a car accident, pay me, I don't ever want to see you again. The path forward is resolving it so that the student can make progress and kind of move forward with the school district. So it's like, a lot of repair has to be done, and so we're working together. It's kind of a unique area of law in that sense, and why I really love it, because you're kind of repairing and working together, and so that makes it so critical, as Stacy was saying, and Steve has said, that in the very beginning, you're recognizing what the issues are, what you can get for it under the law, what a judge is going to award, and advising your client, as such, and then, being able to get on that road to repair. So that the student can be learning, making progress. And that is what we unfortunately haven't seen, is there's sometimes, a lot of, just, I guess, talking about how they should be mad because the school district didn't do this, or, and they've really trampled on your rights. I mean, I've heard that a lot. And yes, in some cases you absolutely need to move forward and have a judge decide, whether, there were violations. But by and large, there is so much work to be done on the front end, in terms of settling. And, Steve and I and Stacy have been working together for years to get a quick resolution to the cases that can be resolved really, really quickly. I remember Steve and I settling a case before the resolution meeting even happened. And that's so important. That's a win-win-win. It benefits the child, it benefits the school district, and they can move forward together. And if you don't have someone who is knowledgeable about that, then it's gonna, it a lot of times falls into that trap of just, being protracted unnecessarily to the detriment of the student.
And I would just add, kind of to pull what Tammy and Steve said earlier together, is that one of my partners used to practice family law, and she said this is like going through an incredibly like difficult divorce and custody battle, and then living together, and having to work together collaboratively like until they're 22. Right. Like, so that is another very like strong reason to find common ground, to get back on the right track, to not have a scorched earth, if you can. and I know that it's really difficult for the school district, like when for their employees when you go through a hearing, as well. I know Steve has said many times that they generally lose at least one of their teachers, after having to go through a special education hearing. And with our teacher shortage, that certainly isn't what we need either. And so really having there are great advocates, that are out there, but I think the really great advocates understand what the limitations are to what they can do, and they know when it's a good time to be able to hand off. And what becomes problematic is when you have advocates that maybe had a bad experience with their own child, and so then this becomes a second opportunity to they're so mad, like they're so mad about what happened, with their child. And so kind of in their and perhaps I don't want to project onto them, but like a lot of our parents, they look back and they're like, oh, I wish I would have done this. I wish I would have advocated, earlier, right? Like maybe I should have done something different. And so this is like a chance to really try to help other people. But in that process, it can make things a lot more contentious than perhaps they need to be.
Okay, so I know I've been asking a lot of questions and you have been providing great answers. So I'm going to open it up to the subcommittee members and to see if they have any questions for you. Do you all have anything? I know, like I said, they've given us a wealth of knowledge in this short period of time. TJ.
Um, I guess I kind of have two questions and they're sort of related to each other. The simple question is, do you have any recommendations for us? But more relatedly, based on what you're saying, is it fair to say that a lot of these issues that have come before the subcommittee are due to the fact that, and perhaps unique to North Carolina, our process is so complex and time consuming compared to a lot of other states? So I guess that's sort of my two-part question. What is this a symptom of a bigger problem that we're dealing with? And do you have a recommendation for what we should do?
Yeah, TJ, I'll jump in. Those are great questions. So I think I shouldn't be careful. My clients would certainly want a more simplified process, right? And that's just a practical reality from a staffing standpoint. It's a practical reality from a budgeting standpoint, and it's a practical reality on wanting to serve kids well and in a timely fashion. So, these cases are, as Stacey just mentioned, brutal on the staff. They are brutal on school budgets, right? The money that goes into these just on defending them. But then, as Stacey said, losing can get very expensive for a school district, and which is fine. That's an incentive to settle early, but it's also a burden on a case where a school system is being asked to do something that they firmly believe is inappropriate, and they're having to defend that at the risk of $250,000, $500,000, depending on how long it goes. So we would love for this process to be simplified. I think the OAH rules that have been proposed, frankly, don't go far enough, but that's not on y'all's plate to decide. I would love to have something that's much more on the record and that had less live testimony and less need for direct expert testimony, but maybe expert reports, competing expert reports, something like that. But that's neither here nor there for you. As far as but it's a symptom of a bigger problem, right? But for this particular process, I think from a recommendation standpoint, it's going to be important that there's a clear line. That the IDEA unquestionably provides space for lay advocates, and so you're never going to hear me say we should shut down lay advocates in the special education process. A parent has a right to that, and in the appropriate spaces and in appropriate measure, it can be very helpful. So I think, as I said earlier, IEP meetings, it can be a great way for a new parent who's struggling to understand this process to have somebody to guide them through it without having to hire an attorney and frankly raise the temperature, right? Because as soon as the attorneys get involved, everybody stiffens up and it becomes much more adversarial, and that's not what we want, and I like the fact that the practices that we have on opposing sides of this get along very well and have the same values at the center of what we're doing, because it does help minimize that sum. But for the staff at the table and for the parent, they don't necessarily experience that because they don't know that history with the law firms and the practitioners. But there needs to be space for lay advocacy in IEP meetings. There needs to be space for lay advocacy in advising parents on the process. Where we run in trouble is when they start advising on the law. And so, am I going to tell you that I think you should exclude lay advocates from the mediation process? No. I will tell you it can be a problem, but it can be helpful. And I don't necessarily think that being in the mediation process is the practice of law. There are advocates who stray into that territory during the mediation process, but the mediation process itself is not inherently the practice of law. I think that at minimum, there's a line with respect to drafting petitions that get filed in OAH, and certainly participating in the hearings at OAH, which is where I think that's where the statute would really come into play on the unauthorized practice of law. So lots of policy considerations around the role of advocates and how effective it is, but that's not really before the subcommittee either. The question is, at what point are they violating the law? And I think that for me, that line is when they start filing things, and when they start serving discovery, and when they start showing up at hearings and expecting to be able to speak directly to the judge or interrogate witnesses or things like that. These hearings are they're closed hearings unless the parent consents for someone else to be there. But so if a parent wanted to consent for the advocate to sit in the back and be there as an emotional support person and to talk to during the lunch break about how frustrated they are, again, not going to say that should be prohibited, but having that person at counsel table and trying to make objections or whispering in the parent's ear to make objections, that's going to be a problem. So that would be my hope, that the subcommittee can kind of hash through those issues. Like, where is the practical guidance? Where are the lines that y'all can draw to say this far but no farther?
And Steve, I'll just ask for you to clarify, because for the subcommittee, like parents can engage in mediation before due process. And so I just want to, like, are you saying that you think lay advocates should be able to be involved in mediation after due process, or the mediation before?
That's a very fair question. So before, certainly. It is more complicated when there's been a petition filed, and I'm operating under the hypothetical here that it's a pro se petition that's been filed. But do I think that lay advocate would be violating the law by sitting in a mediation? I don't know that I would go that far. But that would be something, again, I think the subcommittee should grapple with that particular issue. And thank you for clarifying that. Two different procedural places, right? With mediation beforehand, no question that does not inherently involve the practice of law. Mediation that's part of the petition process is a much more fraught area and would need some very careful thought. Again, I don't know that it inherently violates the law, but it certainly presents a much greater risk.
So I would probably make a more of a clarification that when we are in mediation, there are pretty complex settlement agreements with release terms, and often where you're asking there are settlement agreement because of a recent Supreme Court case. Now there's a lot of discussion about whether you're releasing claims that you haven't even brought, like under other disability statutes for Section 504 and the ADA. And I just feel like when you're looking at the terms of an agreement like that, someone needs to be, I don't know how you don't advise. I don't know how it doesn't cross over like in that point. And that's different than the first step, which is called a resolution session under the law. And when there's a resolution session, it's really designed to be without attorneys. We don't like to go to those. I know some attorneys do, but like we find that it's really designed for the school people to sit down with the parents and to say like, hey, let's see if we can work this out. And what you're doing is coming up with an agreement. It's usually a bullet point list. And the only thing that the parent is agreeing to do by accepting the 50 hours of reading services or whatever is to dismiss their petition that they filed. and they have 3 days that they can change their mind, and the school district has 3 days, like, so both people could go back and like get advice and then decide to change their mind, but you're not crossing over into where you're potentially having other releases. And I just think I just don't know how you could help a parent work through that aspect of a settlement agreement without crossing over the line. And Steve, I don't know about pre-litigation mediation. I don't know that I have any experience that except from a case that we litigated in 2014. So do those mediation agreements also have like general release language and things, or is it just, I don't
Yeah,
know.
so again, all great points, and I will say to the subcommittee, I think Stacy is absolutely right that when you get into those complex settlement agreements, the risk of a lay advocate crossing the line is very high. My point was simply that there can be a lay advocate that's there to help the parent think about what it is they want and then just step out of the way. Is that likely to happen? No, I don't think that's likely to happen, but I wanted to be careful about saying it would be a violation of the law to participate in the mediation session. But I do want to be clear that I agree there's a lot going on there that would present a significant risk that a lay advocate would cross the line. As far as those agreements, yes, they do involve releases. They can involve general releases. I make it part of my practice to try to be fair to the parent if we're in a pro se situation, that I try to explain, while with appropriate caveats, and I'm not giving them legal advice, but that this is my understanding of what we are proposing, to try to be fair to them. We don't try to sneak those things in just because they're pro se. But yes, I mean, we do have those agreements. They do involve releases sometimes. Sometimes they don't. Sometimes it's very simple, and we have an IEP meeting, and the parent is happy with the IEP meeting, and they withdraw the petition. But sometimes we do have releases for specific relief. And again, because I think a parent obviously can, whether they should or not, different question, but they can make those decisions about what they're releasing and what they're getting. The presence of a lay advocate who isn't advising on those things would still be fine if the parent is doing that on ultimately independently as a pro se litigant. So anyway, that's the line I was trying to tiptoe there, is I do think there's significant risk, but it would not inherently violate the law for a lay advocate to be present for a mediation, even after a pro se petition has been filed.
Okay. All right. Any other questions? Jane, you have a question?
If I can get myself off mute. I do have a couple of questions. So is the mediation, the court-ordered mediation once they file the petition, or is there mediation prior to that?
So, so I'll take a first stab, and if I miss anything, you guys can fill in for me. But so under the federal law, like whenever parents and the school like aren't coming to agreement, without filing a due process petition, the parents can ask for mediation, and the Department of Public Instruction will pay for a mediator. It has to be voluntary, so both parties have to agree, to go. And a lot of times I think the cases never get to due process, because if we can sit down and kind of have a conversation and come up with an agreement. But then once due process is filed, there is a mandatory meeting that's called the resolution meeting, and both parties can agree to waive that and go to mediation if they want to. Okay, but nobody can say, like, well, a parent can't say, I'm not going to resolution, I don't want to settle, I want to go to hearing, because then the school district can move to dismiss their case. Okay, so parents, the IDA really wants you to try to settle, and so, which I think is good. But a lot of times what happens, especially when parties are represented by counsel, is that the resolution session is waived, mutually waived, and we jointly agree to go to mediation, because we know, like, at that point, attorneys usually are, in our case, attorneys are involved, we're attending, and it's just a lot easier to kind of hash things out and to get something settled, at that point. But it's not court ordered. There's also North Carolina offers a third opportunity to try to settle, which is an administrative law judge settlement conference. And so unlike like the regular administrative code basically says any party can ask for it and it can be ordered, kind of like a court ordered, settlement conference. But because the IDA requires that mediation is voluntary, then, there's this question of like, can it be ordered on parties if you're, if it needs to be voluntary for both to go. And so the rules are trying to flesh that out a little bit. That issue is also in federal court right now. I mean, but anyway, that's a longer answer like to your question. But so there's mediation possibly before, and then there's mediation after. But both are voluntary under the federal law.
So I may be trying to streamline this too much based upon what you just said, but the questions that have come to us came to us from OAH. So I wasn't sure if you were talking about a mediated settlement conference required by OAH or something prior. So could we draw the line that we're only answering what happens at OAH and beyond, and not to the things that occur prior to, but you said some of these happen after they file a petition and the petition is filed at OAH.
It is. And so that's what I would say, like, is that I think the line should be drawn at the time that the petition is filed. Like that's where I would draw the line. I mean, I understand kind of, I don't disagree with Steve of like just being present at mediation and helping the parent decide how much reading services are you going to ask for or whatever. I don't know that that's a clear violation, but I think once the petition is filed, now you have crossed over that you are in, even though it's a quasi judicial body, like you're still in the legal system as far as these cases, are concerned.
So, and that does answer a question for me. So I feel like once you file something at OAH, it does become legal representation. So who is pushing, and this may be an irrelevant question, who is pushing for these lay advocates to have a role at OAH? And is this something that happens a lot? Or is this just something that's come up a couple of times and they don't know what to do with it?
I think the latter is the more likely answer, at least in my experience. As I said earlier, I've never had a hearing that actually tried to involve the lay advocate in the hearing process. I am aware of pro se petitions where the lay advocate has been in the parent's ear, and I have concerns that they were probably practicing law in an unauthorized fashion, but I didn't know it at the time. I couldn't prove it, and it didn't ultimately come to the fore at the hearing. So I think this is more OAH trying to be comprehensive, and as they're restructuring these rules a bit to determine, what guidance can they provide that's going to help clarify the process, so we don't have arguments in the cases that may come up about these issues. But I'm not aware of it being a rampant issue. I believe that OAH is simply thinking through these issues and saying, hey, we don't know the answer to this, and this is probably outside our jurisdiction. Let's see what the state bar has to say. That's my sense. I don't know, Stacey, Tammy, if you have some other information.
Yeah, I think part of it is also that right now it varies from judge to judge in terms of how much, like one judge may let a lay advocate sit at counsel table and another judge will not, right? And makes them sit like, they can be in the room if the parents want them in the room, but kind of like Steve was saying, like sitting as an observer and perhaps counseling, during breaks, or which they probably shouldn't be counseling, but you know what I mean, like providing support during breaks. So, and I think that's probably part of wanting to be sure that it is not, that there's a clear rule about it. And I think that's why you see in the questions that OAH put forth, I mean, that's one of the questions. Should they be allowed to, to sit at counsel table? Because my guess is that is coming up, and I've had different judges that I know have handled it differently.
And my last question, and I think I know the answer to this because y'all haven't mentioned it. You keep mentioning that somebody's doing rules. I'm assuming it's DPI. They or whoever, they're not addressing the role of the lay leader at all. There are no rules that will address what they can or cannot do. And is that potentially a place where it should be addressed?
How do I answer that? So OAH is actually spearheading the rulemaking process, and that is an issue in dispute, frankly, because DPI, I think, takes the position that they're the one, the State Board of Education is the one that gets to make these rules for the special education process. So that's just layers within layers of what's going on here. But so stay tuned on that particular issue. But yes, right now, this process, OAH, through, I think, largely the efforts of ALJ Stacy Bottenheimer, who handles many of these cases and was a parent's special education lawyer for many years before that, and so has a great deal of expertise in these issues, is trying to help clarify the process, streamline the process. And so that's, I think, where this effort came from. And she's held meetings with the attorneys. We've met with Judge Bottenheimer and some of the other judges and offered some input and feedback. They sent us the proposed rules, and we're going through notice and comment right now, in addition to this. So all of that is happening right now under the purview of OAH, but with the involvement of everybody else. This particular issue, I think, is one that they encountered as they were trying to rewrite those rules and said, hey, this one's outside of our purview. We need some guidance. And so I believe, again, I don't have direct knowledge on that, but I believe that is the source of the letter that you all received and the questions that you got is OAH saying, we'd like to be able to clarify this, but this is outside of our power to do without guidance from the state bar on this issue.
Okay, I'm gonna have to jump in. I have a high school SGA swearing in that I have to do at 1:30. So I'm going to leave it in your hands, TJ, Jane, Tessa. I really appreciate you coming on. Tammy, Stacy, Steve, your information has been absolutely great. Very, very, very necessary. But I have to go, I'm in the country, so I have to drive a million miles to get everywhere I need to go. So with that, I'm going to have to pop off, but I leave it in your very capable hands.
Thank you, Takia. For
Thank
Judge
you.
Lewis Blaylock, I need to
It's
call
all
you
right.
that. I just am
It's
so used to
fine.
calling you Takia
I
before you
know,
were
I
judge.
know. Thanks, everyone.
Yeah.
Thank
I just wanted to ask one last catch-all question, which is, what if there's anything else that you all would like to say about what makes an effective lay advocate? Each of you has touched upon it, but if there's just anything else that you'd like to add about that.
I'm sorry, Tessa, could you repeat that? Your
Sure.
piece went out for just a second there. I want to make sure I heard the question correctly.
Sure, absolutely. So I just wanted to add a catch-all question of, you all have touched upon this a little bit, but of what makes an effective lay advocate.
So I can just start sort of in a practical sense, I think, when it comes, for especially folks who haven't been through like the special education process or don't, know a student with disabilities. They have these IEPs, these, individualized education programs, and they're working with the school to, design the services and, the particular supports and accommodations that they're going to be getting throughout the day. And I think, when they have their IEP meetings to go through, what the students' needs are and what progress they've made, the lay advocates, I think, can play a key role there in talking with the parents about, like Steve said, the process and, that this is the layout of the IEP and, these are the evaluations that your child has, received. This is the information that the team is going to be relying on and talking with them about their individual child's needs. And I think that is really where their biggest value is, because a lot of times parents, they're sort of unsure of that part of the process. It's a huge document. There's evaluations, there's other IEP documents, and sort of navigating all that, they're kind of, it can be overwhelming. And I think an advocate could really sort of help direct them to the important parts of the information and to help them to ask for what they want from the IEP meeting. I mean, from the IEP team. and that's really the start of avoiding all issues and legal issues. But again, I think moving into kind of that area where the advocate starts to advise about, well, the IEP team or the school district didn't do this, and so they violated your rights. That is where it crosses over, because again, a lot of times they're just wrong. I mean, I'll give an example. There might be what we call procedural violations. Perhaps there were sort of, certain things that needed to be done according to a certain timeline. And an advocate, I've had this situation, will give the advice that the client, well, the school district violated this, procedure. And so therefore you have a due process case. You need to go, and file this, because they violated the law. But I mean, we know as attorneys that some procedural violations don't amount to actual harm. And a judge isn't going to determine that, a judge is going to determine there was no actual educational harm. Yes, maybe they missed a deadline, but that's not something to file a lawsuit about and get stuck in court and delay all the other progress that can happen for your student as well. And an attorney is going to give the advice, that advice, and an advocate, if they're advising on these things, which I hear a lot, that's going to be problematic. So sticking to sort of the process, the IEP, the evaluations, helping them to read the documents, and figure out the lay of the land of going through having a student with disabilities and going through the IEP process with the school as a partner.
I'll add, I think, from my perspective, what makes a good advocate is somebody who knows special education, whether because of personal experience, or because they were a special education teacher, but they know special education. I think it is somebody who is at heart a conciliator, someone who's going to help the parent bridge the misunderstandings, bridge the disappointments and the gaps, but to try to stay focused on how do we fix this issue instead of casting blame and trying to set up a case. I think it is somebody who brings an appropriate level of humility to their work. And even as we as attorneys try to do, right, we don't know everything, and I'm always try to be transparent about that. I think a good advocate is one who knows what the limits of their expertise is and is transparent about that. And I think a good advocate is somebody who knows what other resources are out there, that they can help connect parents to if they get outside of that space where they feel like they are serving the process. So those would be kind of the pillars of or characteristics, I think, of a good advocate from my perspective that would help the process. And many of them are in that realm.
Yeah, I don't think that I really have anything to add to that. I mean, I think we do have some really good advocates, and you can tell when there's been a good advocate that's involved and they've asked the right questions, and they've gotten a lot of progress, like for the children. And so we definitely are not looking to not have them at IEP meetings and things. I like I said before, I just think the line needs to be once you start kind of the legal process. I think there's too much, where the unauthorized practice of law like happens, whether people intend it to happen, or not. But I think also because they wouldn't necessarily know that they had crossed that line, and so to me, that's part of kind of the knowing, knowing what you do know and what you don't know. Okay. Don't call me to handle like your traffic ticket because I don't know how to do that, like at all. Like got a law degree, but like I don't know how to do that. But there are people who are really good and I would call them, right? And so I think it's the same idea. Like they have a great area of expertise to be able to bring to the table, but it's not once the litigation starts.
All right. Does anyone else from the subcommittee? TJ? Yeah.
So, do you have any feelings about any sort of level of expertise or experience or qualifications that lay advocates should have to present, or is it just we try, I mean, I don't want to get too bogged down in bureaucracy and that sort of thing, but do you feel like there needs to be some level of qualification for a lay advocate before they can actually get involved to kind of weed out? And yeah, again, based on my personal experience, I've dealt with parents that had really bad experiences with their IEP meetings who talked to other parents and got them all riled up and caused real problems for their kids. So I know, even though I certainly don't practice in this area, I've had the personal experience of it. So do you feel like there needs to be some sort of screening or qualification process for someone to be a lay advocate, or is that too much?
I mean, I think that would, I think that would be ideal, but I think under the federal law, like, I don't think that that could be required. It could, because a parent can bring someone. I know there, like the Council for Parents, Attorneys, and Advocates has an advocate like training court, like different levels. They're a year long, and and those people, I feel like the advocates who take their role like can, I don't want to say seriously, but like, that really are invested in making sure that they have all the information and they will go to some of those like training programs. And that always is nice when I'm looking, at people's credentials to see what steps, just like we all do. Like if you want to learn how to specialize in something or how to get better at it, that's what you do. You take courses in it and you learn. So, and you don't just rely on Dr. Google or AI, I guess, as it is now. So.
I think that's exactly right, TJ. While it would be lovely if all advocates had a certain level of qualification or experience, I think federal law does not uh, allow for that. It would effectively preempt any efforts to do that. And I think the only space we could do that is if we were carving out an exception where they can practice law if they have these qualifications. And I would not get behind that.
Right. So is there anything else that anyone would like to share or to ask? I need to scoot over the little strip at the top of my of my Zoom. I think that's, oh, Jane.
I was just going to say thank you so much for joining us. It's been very beneficial and very helpful. I feel like I know what I think about the situation, and I'm looking at when the petition is filed at OAH, and I'm a little curious as to why they don't see it that way.
I think my guess is they probably do, but I think it's because of that part in the regulations, like that it is by state law, and because our state hasn't actually taken a position on it. I don't think that they feel like that they can, and without additional like a statement like from guidance from the state bar or something else, like to be able to take that step.
But thank you so much. This has been very informative.
We
Yeah,
really
thank
appreciate
you.
you guys looking at it, and taking
Yeah,
this.
likewise. Thank you for the
Yes.
consideration and the seriousness of taking this on.
Absolutely. We're really grateful for your time, you all. Thank you.
All right. Well,
Thank
thank
Have
you
a great
so
one.
much.
For organizing and inviting us. And thank you, Ms.
Absolutely.
Gilchrist.
All
Okay,
right.
bye.
Bye.